Hello everyone, how are you all? I hope everyone is keeping fine and safe. Yes, so let's start our video today. As you see, we were discussing about laws and we started discussing about the law of Tort. Okay, so law of Tort, as I told you, is a very important concept in our syllabus. So we are going to discuss that, and definitely uh, this is going to enhance our knowledge also. So beginning with that, we have already discussed law of Tort in the other video. That's the previous video that had been made. So you can definitely refer to that. I'll advise you refer to that in case if you require any assistance. What is law of tort or what is its importance? The various things have been discussed there. So definitely you can refer to them. And in this video, we are going to continue with the next part of the law of tort. So, law of tort today here that we are going to discuss is in relation to person. Okay. Firstly, we'll talk about assault. Okay. What is an assault? It is an act of one party uh, which puts another person in a reasonable fear of an immediate attack. It is also we can consider an attempt on a threat to cause hurt to another coupled with an apparent or present ability to the intention to do the act basically. Okay, so consider an example. See, A advances towards B with clenched fist, but it was stopped by C. An assault has been committed by A. Again, you can take an example. Pointing a pistol, whether loaded or unloaded, towards the plaintiff is an assault. Next, we come to the discussion of battery. Battery may be defined as the intentional application of physical force to a person of another without his consent or lawful justification. It includes the actual striking of another person or touching him in a rude, angry, and revengeful manner. We can consider examples of A hits B by throwing a stone at him, or X spits on Y's face. Okay, so that's act of battery. Next, we come to defamation. Defamation is the act of lowering down the reputation of a person in the eyes of public. Reasonably prudent or right-thinking members of the society by way of words, gestures, pictures, paintings, caricatures, etc. The term defamation is a generic expression and includes libel and slander. A libel is a defamatory statement made in some permanent and visible form. You can consider the examples of writing, picture, printing, statue, etc. And slander, a slander is a defamatory statement made by spoken words tending to inquire the reputation of the other. Thus, libel is defamation addressed to the eyes and slander, defamation addressed to the ears. It's just the difference of eyes and ears. Okay. So again, I'll repeat myself, defamation and as I told you, it's just the difference of eyes and ears. So yes, there will be few illustrations also which we can consider. But as of now, let's consider libel is defamation addressed to the eyes and slander is to the ears. Okay. Now coming to the essentials of defamation. The statement must be defamatory. Okay. A defamatory statement is one which tends to lower a person in the estimation of right thinking members of the society. It must refer to the plaintiff. The statement must be published. Publication does not mean that the defamatory matter must be published in a newspaper or a magazine. Publication means the defamatory matter is made known by some act or by printing, by making it available to the people. Okay, that is called being available. Okay, So in such a case, there had been various examples of nuisance, of negligence, of defamation. Okay, so we can take an example. A tells B in the presence of C that B is a rogue. That's defamation. Again, A writes in defamatory letter about B, who is blind, and posts it to him in a sealed cover or in a package, knowing well that his wife has to read it for him. That's again defamation. Now, defenses of defamation are also there. Firstly, three categories are there. One is truth, fair and bona fide comment, and privilege. One, the truth that we're talking about is the alleged defamatory statement is substantially true. Even though some details may be untrue, the defendant has complete defense in civil cases. Secondly, we spoke about fair and bona fide comment. A fair and bona fide comment on matter of public interest does not attract any liability unless it is written maliciously. Thirdly, we spoke about privilege. When a person stands in such a relation to the facts of the case that he is justified in saying or writing that would be slanderous or libelous in the case of anyone else, he is said to have a privilege. Okay. Now, since we are talking of privilege, there are two types of privilege that we can discuss: absolute privilege and qualified privilege. So, in matters of absolute privilege, no action lies for a defamatory statement, even if it is false and is made maliciously and out of improper motives. We can take example. Article 105, Section 2 of our Constitution states that no action lies for statements made by members of either house of the Parliament in their places of the houses. However, injurious they may be to the interest of third persons. If we talk of qualified privilege, when the person makes a statement in order to protect his own interest, which may be defamatory when any other person makes the same statement. You can take the example: an employer. An employer tells his employee not to supply goods to a particular client, but he believes that the client has no intention to pay for the goods. The employer is protected by qualified privilege as he's made the statement to protect his own interest. Next, we can talk of nervous shock. Earlier, no action could be taken for any mental suffering or emotional disturbance caused by the negligence of the defendant. However, it is now recognized that if, by reason of an acute shock to the nervous system, the activities of the body are impaired and incapacitated from functioning normally, there is a clear bodily injury. Okay, so in that case, action will definitely be taken. Let's consider an example. The defendant, by way of practical joke, informed the plaintiff that her husband had his leg broken in an accident. The plaintiff got a nervous shock and became seriously ill. Hence, the defendant was blamed. Okay. The next we are going to discuss about is negligence. The word negligence, we know the meaning very well. The word negligence refers to the breach of a legal duty to take care which results in damage to the plaintiff. Negligence is the absence of reasonable care taken that or needs to be taken. What can be the elements of negligence? First, that there was existence of a legal duty to take care owed by the defendant to the plaintiff. Secondly, there had been a breach of that duty by failure of the defendant to take such care as a reasonable man would have taken. And thirdly, that as a result of the breach of duty referred, the plaintiff has suffered damage. You can consider examples of the word duty in this context. The duty of care to pedestrians and other road users while driving a vehicle. Also, you can take the doctor's duty to his patients. Okay. Next, we can discuss about concept of res ipsa loquitur. This maxim literally means the thing speaks for itself. The general rule is that the burden of proof of negligence lies on the plaintiff. There are, however, certain cases where the plaintiff is not required to prove negligence because the accident speaks itself. That is, the facts are strong in favor of negligence on the part of the defendant. The plaintiff has to simply show that the accident occurred. For defense, the points that I'm going to say will be available and will be proven for action against negligence. Firstly, denial by the defendant that he owed any duty to the plaintiff. Number two, denial by the defendant of failure to take reasonable care. And number three, voluntary non-fleeting injury. Okay, that's discussed in the previous video. Now we are going to talk about nuisance. Nuisance, the tort means uh, unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. You can consider examples of nuisance: smoke, fume, smell, heat interfering with the health of others. Okay, now firstly, let's take public nuisance. It is an act or commission which causes any common injury, danger, or annoyance to the public or to the people who occupy property in the vicinity. It also includes nuisance which endangers the health, safety, or comfort of the public. To make nuisance an actionable tort, it is essential that the following factors that I'm going to discuss coexist. Firstly, it's a wrongful act. Secondly, injury and damage or loss or inconvenience caused by such act to another. Thirdly, such injury must be direct. Fourthly, the injury must be shown to be of a sustainable character and not fleeting. Next, we can talk about private nuisance. The first one we have been discussing about public nuisance, and this is about private nuisance. A private nuisance is some unauthorized use of a man's own property, causing damage to the property of another, or some unauthorized interference with the property of another, causing damage, but not amounting to trespassing. To take example, any abnormal noise or unusual noise may cause discomfort and disturbance to the neighbors and may create or constitute nuisance. So, essentials of private nuisance: firstly, there must be interference with the use of enjoyment of land or some other right over it. The plaintiff must show title to the thing to which the nuisance is alleged to be caused. And thirdly, the act complaint of must result in damage to the plaintiff. The nuisance is not actionable per se. Some damage must have been caused to the plaintiff to enable him to sue. Okay, now you can go through the examples we can learn about the landmark cases through which law of torts has evolved. There are various cases, and do pay attention as to how law of torts has evolved. Various cases that we're going to discuss now. First, Ashby versus Lloyd. In this case, the plaintiff was a valid voter at a parliamentary election. The defendant, the returning officer at a voting booth, wrongfully disallowed the plaintiff from exercising his franchise. Now, there was no loss, monetary or otherwise, suffered by the plaintiff. Even the candidate for whom he wanted to vote won the elections. Nevertheless, the plaintiff succeeded in his action against the defendant for the simple reason that the plaintiff's legal right was violated. The next case was Bhim Singh versus State of Jammu and Kashmir. An emissary of Jammu and Kashmir Assembly The plaintiff was wrongfully arrested and detained by the police while he was proceeding to the assembly. Further, he was not produced before the magistrate within the stipulated period of time that he was supposed to be done. This act was a violation of both his fundamental and legal rights. Finally, it was held that the state was liable and was compelled to pay damages to Mr. Haynes. Next, we have the case of Gloucester Grammar School. In this case, the defendant, a school teacher, set up a rival school in the same locality. As he charged low fees, students dropped out of the plaintiff's school and joined the defendant's school naturally. The plaintiff contended that the defendant had intended to cause wrongful loss to him. It was held that the plaintiff had no remedy as there was no legal wrong committed by the defendant. Thus, in this case, there is monetary loss to the plaintiff, but there is no violation of his legal right. Hence, there is no case of tort. Thus, a legal act has been done maliciously will not make a defendant liable. Only if the plaintiff shows that he has suffered injury on account of the defendant or the defendant's illegal act, then only he can claim damages. The next case we had was relating to this one I have been discussing about grammar school. The next one we have is again relating to Haynes Hall versus Bookmark Auto Racing Track. So the plaintiff was a spectator at a motor car race. Okay. Due to a collision between the two racing cars, one of it rammed into the spectator's stand and injured the plaintiff. The court held the organizers were not liable as the plaintiff he himself had impliedly took the risk of such injury. The next case was Haynes versus Harwood. This is a very famous case. In Haynes versus Harwood, the defendant left a horse carriage outside a building, absolutely unattended. Some urchins playing nearby threw stones at the horse. The horse unbridled itself and started running amok. The frightened passerby and everybody started running. A police constable who was on duty in a nearby police beat box decided to take charge of the situation and succeeded in stopping the horse. In the process of doing so, he sustained injuries and claimed damages from the defendant. The defendant was held liable and was prevented from setting up the defense of voluntary non-fit injury. The next we have is Stanley versus Powell. One of the members of the shooting party accidentally shot at another member, mistaking his movement for that of an animal. The court held that the injury was an accident. The next case that we had is Brown versus Kendall. Again, this was a very famous case. In a fight between two dogs, one belonging to the plaintiff and the other to the defendant, while trying to separate the dogs, the defendant accidentally hit the plaintiff, who was standing close by in his eye. Held that the defendant was not liable as the injury to the plaintiff was the result of a pure accident. Next, we have Spot versus Shepherd. A threw a lighted firecracker aimlessly in a crowded marketplace. It was about to land on a sweet stall. The owner of the shop, acting in self-defense, quickly picked it and threw it. It fell on the plaintiff, held that the sweet stall owner had acted in private defense and hence it was not liable. The next case we are going to discuss is State Bank of India versus Shamadivi. The respondent, Mrs. Shamadivi, opened a savings bank account with the plaintiff's producer, Imperial Bank of India, at its Allahabad branch. Respondents gave some cash and check to one Kapil Dev Shukla, who was a friend of the respondent's husband and employed in the said bank, for being deposited in her account. The said payments were made to Kapil Dev Shukla in his capacity as the respondent's husband friend. No receipt or voucher was obtained indicating the said deposit. The bank servant, instead of making the deposit in the respondent's account, got the check in cash and misappropriated the amount. He, however, made false entries in the respondent's passbook and the bank's ledgers outside the course of employment, and the appellant bank could not make such liable or could not be made liable for the fraud committed by its servant. The next case we are going to discuss is Lloyd versus Grace Smith and Company. Miss Lloyd approached Mrs. Grace Smith uh, and Company to seek investment related advice. The clerk who attended upon her asked her to sell her properties and then reinvest the proceeds. Miss Lloyd signed certain documents which were supposed to be of the sale deed. Actually, it turned out to be a gift deed in favor of the clerk. The clerk disposed the property and misappropriated the funds. It was held that the company was liable for the fraudulent acts of the clerk. Next, we come to the discussion of Morris versus C.W. Martin and Sons Limited. The defendant was running a dry cleaning service. A fur coat entrusted to him for dry cleaning was stolen by one of the servants of the company. Held the defendant was liable for the theft of the servant. Next, coming to Bailey versus Manchester Sheffield. A railway company appointed porters to assist passengers to board the right trains. One passenger had got into the right train, but a porter erroneously thought the passenger was on a wrong train. He therefore pulled him out and pulled him in another train. Held the railway company was liable for the mistake of the servant. The next case we are going to discuss is Century Insurance Company versus Northern Ireland Road Transport Board. A driver, let's consider a driver of a petrol tanker, was B servant. While transferring petrol from a lorry to an underground tank, he struck a match to light a cigarette and carelessly threw it on the floor. This resulted in a fire and damaged the petrol tank. Hence, the master was liable for the servant's negligent manner of doing the work. The next we are going to discuss is Ricketts versus Thomas Stilling Limited. The driver of a bus asked the conductor to drive the bus. The conductor drove the bus negligently and knocked down a pedestrian. Hence, the master was liable for the negligent delegation of work by the driver. The next case, a famous one, Headmistress Government Girls Higher Secondary School versus Mahalakshmi. The plaintiff was a 9th standard student in the government managed school in the first period. The ayah employed by the school had a duty to arrange water for the school children. On 7th August 1987, instead of bringing the water herself, the ayah asked the plaintiff to fetch water in a plastic pot on the career of a cycle from a tube well about 1.5 furlongs away. While the plaintiff was placing the water pot on the cycle career, the career of the springer, that's the career of the cycle that we call the spring, came out forcibly, hitting the plaintiff's right eyeball, and she lost her right eye in that accident. The school authorities and the state were held liable for the negligent delegation of the authority by their servant, that was the eye. The next case we are going to discuss is Beard versus London General Omnibus Company. The driver of a bus had gone to have his dinner, leaving the bus in the custody of the conductor, who decided to turn the bus to keep it in a readiness for the return journey. While doing so, he negligently knocked down a passerby. Hence, the master was not liable as the conductor acted outside the course of his employment. The next case we are going to discuss, Twine versus Beans Express Limited. He provided a van for the use of a bank. He put up two notices on the van, which read that no unauthorized person is allowed to take a lift in the van. Also, that the driver had been expressly told not to give or not to lift to outsiders. The driver nevertheless gave lift to an unauthorized person who died in an accident caused by the driver's negligence. Held that A was not liable for the act of giving lift was outside the scope of employment. The court held that giving lift to an unauthorized person was not merely a wrong mode of performing an act, but it is a performance of an act of category for which the driver is not employed to perform a job. The next case we are going to discuss is Sitaram versus Shantanu Prasad. Sitaram, the owner of a car, had entrusted it to one Muhammad Yaqub for plying it as a taxi. The said driver appointed a cleaner. One day, the driver allowed the cleaner to use Sitaram's car for the purpose of taking a driving test. While taking the test, the cleaner injured a spectator. It was held that the owner was not liable, for the owner had not authorized the driver to employ strangers. Secondly, the cleaner at the time of the accident was not doing the master's work. Thus, the negligence of the servant took place outside the scope of the employment. The next case we are going to discuss is Convey versus George Booney and Company Limited. In this case, the defendant, who were a firm of contractors engaged in a building work at an aerodrome, had provided lorries for conveying their employees to various sites. A notice was displayed in every lorry that the driver was under strict order not to carry passengers other than those employed by the defendants, and that any other person traveling in the lorry did so at his own risk. Oral instructions to that effect were given to the drivers as well. The plaintiff, who was a laborer in another firm, was given lift by the driver of one of the defendant's lorries and was injured due to the driver's negligence. It was held that the act of the driver in giving lift being outside the scope of his employment, the defendants were not liable to the plaintiff. It was observed that giving lift to an unauthorized person was not merely a wrongful mode of performing the act of the on the class of this driver that was employed to perform, but the performance of an act of a class which he was not employed to perform at all. The next we can discuss is Lemers versus London General Omnibus. The owner of a bus had given express instructions not to overtake or race with other vehicles. The bus driver, defying the instructions, overtook another bus and in the process caused an accident. However, the bus owner was held liable for the negligence of the driver. The driver's negligence indeed took place within the scope of the employment. The last one we are going to discuss is Terry versus Ashton. A person got a lamp fixed on the outside of his house through an independent contractor. The lamp, which was negligently fixed, was overhanging on the footway adjoining the person's house. It fell down and injured a passerby. It was held that the person who got the lamp fixed was liable, for he has a duty to see that the job he has done was properly done. So these are the few cases that had been promoting torts. So these are few important ones which are also important for your examination. So do read them out, do follow them out, and the entire discussion of torts have been done. So you can definitely refer to them if you require or need detailed help regarding the discussion. So I'll end my video here. Thank you for watching me and watching this video. All the best for your exams. Thank you.